Mochi Health is here to help you start your weight loss journey with caring, personalized support. Meet one-on-one with board-certified obesity doctors and registered dietitians who truly listen and understand your unique needs. Eligible patients can access affordable GLP-1 medications delivered right to their door each month. No insurance? No problem. Mochi Health accepts FSA and HSA, making care accessible and affordable. And with 24/7 customer service, you'll never feel alone on your path to better health. Get started with Mochi Health today. Take the free quiz at joinmochi.com and use code AUDIO40 at checkout for $40 off your first month of membership. That's joinmochi.com with promo code AUDIO40.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my unavailable co-host, Brett.
It's right, Alice.
It's true on so many levels.
I just love it. I love it. I love everything about your puns, Alice. They make my day.
I appreciate it. You know, when we're reading our 1-star reviews or we meet people, it's not uncommon that people are like, so how long have y'all two been together? And we're like, approximately 5 years as prosecutors and 4 years as podcasters. Oh, you meant in that sense. No. But unavailable also, because I know you guys are all just like at the edge of your seats wanting to know when you can admit something as admissible and exception to hearsay if the person who would otherwise be testifying is unavailable and not in the relational sense.
Right. This is probably one of my favorite of the exceptions. I don't know why. It just it just is for some reason.
It makes me giggle because before we started recording, I was saying that I remembered some sort of like Matlock kind of legal drama about these rules, and we'll talk more about them as we go through them. But each one is written like a little soap opera.
It's true. So you guys who are still with us, you wonderful, nerdy people who I love more than anything, you've been with us now through 2 Hearsay episodes. We have just been diving into this whole idea of hearsay. After we finish today, you will be certified hearsay experts. So get excited.
Actually, this is probably more than you will get in like a Barbary course to prepare for the bar if you're a lawyer. These 3 episodes, they're going to be like close to 3 hours. I think this is more than you would get in probably like a 2-hour lecture. So you're welcome.
So true.
It was for free.
Yeah, you're ready for the bar exam, but don't hold me to that.
Yeah.
So in our first episode, we talked about sort of things that aren't hearsay. Things like statement of a party opponent. Jamie was in Facebook. She's in the chat now. She was wanting to know, is the state a party opponent? And it's not. In criminal law, the party opponent tends to be the defendant when it's a criminal case. And there are reasons for that. Number one, prosecutors are not a party opponent. They're also not witnesses, and nothing they say is evidence. So if you have, say, a hung jury and you're going to have a second trial, you couldn't use what the prosecutor said in the first trial as evidence in the second trial. In fact, you can't use what the prosecutor said in the first trial as evidence in the first trial. The judge will often give an instruction to the jury that nothing the attorneys say is evidence. In the same way, even though the party opponent rule applies to the defendant, it would not apply to his defense attorneys. So anything they say can't be used.
We're not going to dive into it today, but this has come up in a very recent filing in a case that you guys have all heard about, probably the Delphi case, where there's kind of these allegations that the prosecutor is going to be a witness because they are a witness to certain things. And that's really interesting because I can understand how it may seem confusing why the defendant is a party opponent, but the prosecutor is not. And that's because the prosecutor is not part of the suit. right? The case is not Brett versus defendant. The case is the state versus defendant. Brett, the prosecutor, is an agent of the state, but Brett himself can be replaced by another prosecutor, and that happens a lot. If Brett were to leave, another prosecutor would take his place. Another prosecutor might continue on that case or join him for trial. And so Brett is a stand-in for the state, but he himself is not like the state that comes after the defendant.
And if you think about it as the job of the jury is to weigh evidence, the defendant who is being accused of a crime, the things that they say to their friends, for instance, I killed her, I hated her, whatever, you can see why that's evidence, because it is the statement of the defendant themselves. You know, in the Adnan Syed case, the prosecution decided that one of the phone calls was the come get me call. Okay, that's their theory. That's not evidence. It's not a fact out in the world. And so if he was tried again for some reason, the state wouldn't be held to what some prosecutor said in a closing argument. They would be able to present the evidence to the jury, and the jury would decide. So it's always evidence-based. You know, we're talking about this in terms of hearsay, but really hearsay is not even the problem. What I say in court is not evidence. What I say, if I'm a defense attorney and I say something to the press, not evidence. That can't be used against my client. It's not even admissible evidence. So therefore, it's not, how do we get this evidence in under the hearsay rules? It's not even evidence at all. So it's, to even conceptualize it as hearsay is a little strange. Now, in a civil case, obviously both sides are parties. Both sides' statements can come in under the party opponent rule. So that's something that's not hearsay. You don't have to worry about it. Then you get into hearsay, which was, as we said before, statements made outside of court that you're trying to introduce into evidence for the truth of the matter asserted. So you're using it as evidence to prove something. And we talked about a whole bunch of exceptions. And the exceptions we talked about last time were the exceptions that apply whether or not the declarant is available. So the witness could be sitting in the courtroom ready to be called. But if you have one of those exceptions, you can bring that statement in regardless of whether you call them or not. And the idea is that those statements have a particular air of truthfulness about them. And so we're less concerned about those statements coming in, even if the person who made them is not required to testify. The next group of statements, they're statements that we actually don't trust quite as much as we do statements made under the exceptions that we talked about last time. So they can't come in if the person who made the statement is available to testify. They can only come in if for some reason, which we're about to get into, they are unavailable.
Absolutely. So what does that mean? What does it mean to be unavailable? We joked a little bit that there's some colloquial definitions of unavailable. Well, the Federal Rule of Evidence 804 tells you just that. So the criteria for being unavailable is that a declarant is considered to be unavailable as a witness if the declarant is, and there's a bunch of subparts. We'll go through each of them. First, is exempted from testifying about the subject matter of the declarant's statement because the court rules that a privilege applies. So what sorts of privileges are we talking about? We've talked about this a lot. There aren't actually that many privileges. And note that the court itself has to rule that the privilege applies here. You can't just kind of assert that there is a privilege. So there's steps to being unavailable under this first rule.
Exactly.
Okay, second, the declarant refuses to testify about the subject matter despite a court order to do so. Number 3, they testify to not remembering the subject matter. Number 4, cannot be present or testify at the trial or hearing because of death or a then existing infirmity, physical illness, or mental illness. Or 5, is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure. 1, the declarant's attendance in the case of a hearsay exception under Rule 804b1, or the declarant's attendance or testimony in the case of a hearsay exception under Rule 804b2, 3, or 4. Those are all the ways you can be unavailable. And do you guys see why, if you listen to our previous episodes, I said that the one thing I always have with me when I go to trial is my trifold that's like a 11 by 14 page of hearsay and the exemptions and the exceptions and all the explanations behind it, because there's a lot.
Now, these are supposed to be the times where it's okay for the person to use their statement even though they're unavailable. There's one situation in which you don't have to show that any of those apply, and that's when you kill the witness or you do something to prevent them from showing up. So it goes on to say, this subdivision does not apply if the statement's proponent procured or wrongfully caused the declarant's unavailability as a witness in order to prevent the declarant from attending or testifying. So essentially, if you murder the witness, even if none of these can be said to apply, though death seems like it would apply in that circumstance, or you pay them off, there's other ways that you could do it, then you can get the statement in even if these don't apply. So in general, what are these circumstances? What does this really mean? You plead the fifth, that's one. You're now unavailable to testify because you're pleading the fifth. You say, hold me in contempt, throw me in jail. I don't care. I'm not going to testify. Imagine a circumstance in which a parent has given a statement to an officer and then refuses to testify, even if they're subpoenaed. Well, that might be a circumstance in which this applies. You're dead, or you're so ill that you can't testify, or in between when you gave the statement and now you've lost your mind. You don't remember it anymore. Those are the circumstances. And this is just the first step of this. The first thing you have to show is someone is unavailable. Then you have to show one of these exceptions apply. So now we're going to go through the same sort of list of exceptions that we went through last time. But this time, the first thing you have to show is unavailability. If you don't have that, you
and
can't
real quick,
use these
just to give an
examples.
example of it recently, correct me if I'm wrong, because I didn't watch the entire trial, but Ethan Crumley's mom was on trial and he refused to testify because he pled the fifth. And that made him unavailable because you do not have to incriminate yourself. By the way, even if for some reason he couldn't plead the fifth and the court ordered him to testify and he was like, nope, not going to testify, that would also fall under one of the reasons to make him unavailable. And so he had written a lot of things. Writings, remember, are hearsay. The police can't just enter their written report as evidence. We've talked about this. They can't even read from it. They might be able to refresh their recollection with it. But generally, even if you are the person to write and it's completely uncontested that you're the person to write it, that's still hearsay. But because Ethan was unavailable to testify as a witness, they could use his journals in trial.
Yeah. And one that's interesting, you can't manipulate this. So one of the ones we used was they're not there, and the side that wants to put it on attempted to get them there. So you can't not subpoena someone, then say, well, we wanted them to testify, but they're not here. No, you have to act in good faith if you're going to use one of these exceptions.
I'll use a couple examples. Things that have happened in my cases. We tried to subpoena a witness, and the witness was undergoing cancer treatment. And because of their immunocompromised system, they could not get on a plane. Not to mention they were incredibly ill and on death's doorstep. So that, and you have to present all this. There were doctors, medical records to show their unavailability, and the court heard all of this evidence. So it wasn't just blanketly asserted by me.
Okay, but let's assume that you've shown the person is unavailable. So here are some exceptions. So the first exception, if they're unavailable, is former testimony. So testimony that was given as a witness at a trial, hearing, or lawful deposition, whether given during the current proceeding or a different one, and is now offered against a party who had, or in a civil case, whose predecessor in interest had, an opportunity and similar motive to develop it by direct, cross, or redirect examination. So, generally speaking, if there was testimony in a former trial or hearing or any circumstance in which the adversarial process is working and the other side's interest would have been represented, and now that person is not available, you can introduce that evidence at trial. Now, there's a couple things that are important. You may remember from the first time when we talked about this, there were statements that you could bring in that were made during prior hearings, prior trials, whatever. And you could bring that in even without this whole unavailable thing. But remember, there was an important thing about that. That was to impeach their testimony. So it was if something that they are testifying about at the current trial, if you've got something that was inconsistent from a prior trial, that is not hearsay, and it can be introduced as evidence to prove something. This is a little different. This is if Murdaugh had another trial and one of the witnesses in between now and then died. You could put their entire testimony in as evidence because they're not there. Now, what you could not do if they had another trial is you forgot to subpoena them, so they didn't show up for this trial, and you're like, well, shoot, we really needed that. Can we just introduce what they said before? No, because in that circumstance, they would not be properly unavailable.
And just so you know, because we've talked about this a couple times now, there's not a deadline by which to subpoena witnesses in a trial. So there's no excuse. It's not like, I missed the deadline. Like, we actually find out new information during trial, and we're like, we need to subpoena them later on in this trial. So it's not meant to be a gotcha at all. In fact, it's meant to be the opposite of a gotcha. It's meant to prevent any sort of gamesmanship with this exception.
Somebody mentioned depositions. It depends. Once again, don't forget the second part. It has to be a circumstance in which the other side has an opportunity to develop the testimony through an examination of some sort, cross-examination, redirect. It has to be something like that. It can't, for instance, be an affidavit. You can imagine somebody signs an affidavit and then dies, right? That isn't going to count for the purposes of this exception. You'd have to figure out some other way to get that in.
And there's no cherry picking either. This is actually for anything you introduce in trial, whether it's one text or one email or the entire transcript of the former testimony. Basically, what happens is the whole thing should be entered into evidence, but no one really wants to sit there and read back a transcript that maybe went on for 10 hours because that's a waste of everybody's time. And so likely what would happen is the parties would get together and the side using it will say, hey, all that really matters to me is, pages 3 through 33. And then maybe the other side will be like, that's completely out of context. We demand the whole thing. Or they'll say, no, it needs to be 3 to 43 to get the whole context. And there's back and forth. This is why you have to be on your feet at all times. This works for anything, not just for hearsay exceptions to enter into testimony. You always have to think, and this is a very lawyerly thing to do, is to have a witness look at a text message completely out of context or an email completely out of context. And a good lawyer always objects and says, excuse me, is that the entirety of the testimony, the text chain, the email? And entirety obviously can be subjective, right? Especially if you have a long text chain, a long email chain, a long testimony. And so you can make the other side's life bad by forcing them to read the entire thing. But typically, it's in everyone's interest to get to the parts that matter. But again, no gamesmanship. You can't just excise the parts that you want and leave out the cross-examination where they completely undercut everything they said. And this is why you have two sides, because maybe the one side will present the part of the testimony where it was just the direct and it was perfect for their side. But then defense will be like, well, now let's bring up what happened in cross.
And the rules provide that sort of any type of evidence like that, the other side, the side that is being entered against, can require that everything else be read. So that includes like a wiretap or a video. You want to play the 2 minutes of the video that are relevant. If the other side really wants to demand it, we'll sit here and watch the whole hour. And
bank records. That happened to me one time. Like when you have bank records for some sort of money laundering case, it's usually 1 or 2 transactions that matter. If you've ever looked at your bank statement, there's probably a lot of transactions. And I had a real friendly opposing counsel who once said, I'd like every single line of the statement read. And I was like, let's do it.
Fun times.
Fun times.
Fun times. Okay. The next one here, Alice, I'll let you do this one because this one's really the best one. So.
Oh, thank you. This one is the best one. This is what I was thinking of when I said that this rule is like a soap opera. So the second thing, if you're unavailable, is an exception, is excluded from hearsay. And that's a statement under the belief of imminent death. Note, it's not necessarily under imminent death threat. It's the belief of imminent death. Now, in a prosecution for homicide or in a civil case, a statement that the declarant, while believing the declarant's death to be imminent, made about its cause or circumstances. So this is the fun part because you don't actually have to end up dying. You just have to think you're dying. And the idea is same as what we said last time under 803, which is that the idea is that you don't lie as your dying breaths, right? What you're saying is true because you have nothing to lose.
And now you may be saying to yourself, I don't know about that. Is that true? Would you really not lie as you were dying? I mean, maybe you wouldn't, maybe you would. Remember, these are statements that we want there to be a way to get in, but we recognize they might not be as reliable as some of the other ones.
I mean, what we're thinking about is Joe did it.
Killed me.
Joe did it. Brett stabbed me, right?
Stabbed me, and then dies.
They could have been lying, but, that would have been like the last thing they ever did on this earth was to screw over that person that they used their one dying declaration on.
And then note if they then recover miraculously. If you can show that they really believed they were going to die when that happened, and they're unavailable for some other reason. So imagine that they're like, I have forgiven Joe, and I will never testify against him because I've forgiven him, and I think it should stop there. Well, then all of a sudden they're unavailable, and you could bring in that dying declaration. Now, usually, dying declarations, as the name implies, the person is dead. So they are unavailable. But this is one that's famous. You see it all the time. And it's a fun one because of that whole, they just have to believe they're dying, not that they're actually going to die. And in the same way, if they didn't think they were going to die, but died anyway, then what they said doesn't count. So there was a senator / governor, I can't remember what all he was in Louisiana, Huey P. Long, and he was assassinated. He was shot by a guy in the Capitol, and he should have survived, but they took him to the operating table, and he wouldn't shut up. He kept telling things to his secretary, and he had all these things that he wanted him to do, and so he wouldn't stop talking. And basically, by the time the doctors were able to get him where they could do surgery on him, it was too late. He died. Well, he obviously didn't think he was going to die. So even though he died, all those statements he made would not fit within this exception.
Another one is a statement against interests. So what does this mean? It's a statement that a reasonable person in the declarant's position would have made only if the person believed it to be true, because when made, it was so contrary to the declarant's proprietary or pecuniary interests, or had so great a tendency to invalidate the declarant's claim against someone else, or to expose the declarant to civil or criminal liability, and B, is supported by corroborating circumstances that clearly indicate its trustworthiness if it is offered in a criminal case as one that tends to expose the declarant to criminal liability. So something that no one kind of in their right mind, if they were actually testifying in court, would say out loud.
Yeah. So basically, in that circumstance, it would be a situation where, say somebody's on trial for a crime and they have their accomplice or someone else says something that incriminates that person, but also incriminates themselves. And sort of the idea is, would you really say something that put you in such a bad light if you weren't telling the truth? Now, we have some protections there that you have to have these corroborating circumstances as well. And you can imagine just sort of all sorts of statements that someone might make in various criminal cases or civil cases or whatever, that just because of their nature and how bad they make the person look, there's no way you would say that if it weren't true. And that's sort of the idea.
Murdaugh confessing to a bunch of federal tax and wire fraud crimes in his murder trial.
Yeah, exactly. Or, here's one that, imagine Murdaugh, his defense was he was with somebody else. He was having an affair. And the woman who he was having an affair with was also married. And at some point told somebody, I know he didn't do it because he was with me that night. We were having an affair. Well, Murdaugh would say, and then say she got hit by a train. So Murdaugh would say, by saying that, she's saying that she's an adulteress. She's putting herself in a position where she could lose her marriage, where any number of bad things could happen to her. So she wouldn't have said that if it weren't true. And so I should be able to bring it in, even though it's hearsay. That might be an example of when this would come in. And because Murdaugh is bringing it in, he doesn't need that corroborating circumstances thing, because it's not being used to expose him to criminal liability. And it's not being used to expose the woman to criminal liability. And so since you don't have that aspect, you wouldn't need to do that. And you see that sometimes in these rules, where the rules are more stringent when applied to the prosecution than they are to the defendant, because once again, we're trying to make this fair to the defendant. So sometimes the defendant can do things that the prosecution can't. You may recall the last time we were talking about this rule, we can't introduce police reports. There's a rule against that, but the defense could if they wanted to. So it's one of those circumstances.
And guys, remember to keep in mind what this means. All this means is that the jury gets to hear this. They still have to weigh the credibility of what's being said. So maybe there are other reasons to not believe that the two are having an affair, for example. So just because the jury hears it doesn't mean it's gospel, doesn't mean it's not uncontested, doesn't mean that the jury even has to believe them. It literally means, can the jury's ears hear it? So that's what we're talking about. This is the gate into it. Because I know a lot of people are like, well, a lot of people lie on their deathbeds, well, just because it's against their interest. How do we know it's true? Maybe they're just a pathological liar, and then we're completely misled on what actually happened in a case. That could all be true. And there will probably be other things that come out in evidence that may challenge this statement. But whether you get to even bring in the statement at all is what these rules are about.
And that's so important, because these are rules of admissibility, not weight. Determining weight is for the jury. This is purely, does it come in or not? So it might come in and the jury thinks, I don't know why that came in, because that's a waste of time. It's just, can you say it in their presence or not? Okay, so the last one in this, actually, there's one more. So this is a statement of personal or family history. Now, you may recall back in 803, there was reputation concerning personal or family history. So just sort of what everybody in the community says, you can get in whether or not the declarant's available or not. So if there's sort of a general idea, general family lore, that sort of thing, that can come in. This is more specific. This is a statement by the declarant about their own birth, adoption, legitimacy, ancestry, marriage, divorce, relationship by blood, adoption, similar facts of personal or family history, even though the declarant had no way of acquiring personal knowledge about that fact. So for instance, John said that Bob was his dad. Now, John doesn't know whether Bob's his dad or not. He believes he is, and he said that. And then John gets hit by a train. and for some reason, the fact of Bob being his father is relevant in some sort of case. You could use that in those circumstances. Now, if you have a general reputation that Bob was John's dad, then that can come in even if the declarant is available to testify. That's under the last rule. But if all you have is one person saying something about their own family history, if they are unavailable, it can come in. And it can also come in if they're talking about any of those facts about someone else, if they're related by blood, adoption, or marriage, or so intimately associated with the person's family that it's likely to be accurate what they said. So if they're saying someone else was Bob's dad or whatever, if they would know that because they were married to him or they were close to him, you can prove that they should know that. And for some reason, this is important to your case. You can get that in if they're unavailable. This marriage stuff, I guess in family court is where this becomes important. Not something that we typically see in our cases.
And that brings us to the last one. This one's much shorter than last episode. The last one, if you're unavailable, that's allowed in, is statement offered against a party that wrongfully caused the declarant's unavailability. A statement offered against a party that wrongfully caused or acquiesced in wrongfully causing the declarant's unavailability as a witness and did so intending that result. So this last one is meant to prevent gamesmanship, essentially.
Right. And you could have done this in any number of ways. You know, you could have sent them to Fiji on a vacation or something. I mean, there's basically, if you're somehow causing a witness to be unavailable, whether it's killing them, paying them off, whatever, we're just not going to let you do that and keep statements out. So if you do that, pretty much any statement that witness made is going to come in. So this is a pretty powerful rule because it's very broad. It's not subject specific. It's you did this thing, and so now whatever they said is going to come in.
It's kind of like unclean hands doctrine, right? That's kind of a general doctrine, basically saying if you have unclean hands, you are the cause of, this wrongdoing. You don't get to benefit from your wrongdoing.
And so, we've talked about all these exceptions to hearsay, and you might think, man, that's so many exceptions. Well, just in case that wasn't enough, there's also Rule 807, which is the residual exception, which is a catch-all. So basically, if you have a statement that is hearsay, and you can't come up with any of these enumerated reasons, you can't figure out one of these 30 reasons that we've given you about why this should come in. If you can convince the court that that statement is otherwise reliable for similar reasons as these other ones, if you can say, well, look, we have this rule under 803 because of this statement doesn't fit under that, but it has a similar feel of reliability. The court can let it in under the residual exception, even though you don't have a reason you can point to. And hearsay, man.
Here's the thing about this. Now you've learned all the hearsay rules, and you may be thinking, okay, I'm a studious, person. This is a math problem. I will walk into court and I know exactly which rule to cite and which example is going to fit perfectly. Guess what? As just about all things other than a jury verdict, the hearsay exceptions, rules, admissibility is determined by the judge. So you present your argument as to why something should be admissible or not. The other side opposes it. You are both using the rules. And the judge ultimately rules upon the admissibility of such statements. And that's what we have judges for. I mean, this is why trial level litigation is truly like one of the most exciting / terrifying professions I can think of, because so much control is outside of your hands. You could do everything perfectly, quote unquote. There is no science or math proof that's always going to give you the same result. I can walk in with the same statement, the same kind of set of circumstances, same judge, and the judge could rule differently depending on the case. So you have to constantly someone mentioned earlier, law seems like a constant game of chess. It is. It is a constant game of chess. And to be a good lawyer means you're able to see 5, 10, 20 steps ahead. And not only that, but know 20 other contingency plans as to what could happen at every single play and to adjust accordingly to result in the best outcome for your side.
Now, there's one other thing that I think we have to mention, and that's Crawford. So we've been talking about hearsay, and we've been talking about the rules of evidence and when stuff can come in. But there is something that trumps the rules of evidence, and that's the Constitution. And as you guys know, you have a right to confront witnesses against you. And the Supreme Court has said that means in certain circumstances, even if a hearsay exception would apply, the evidence can't come in unless the person testifies. Where you see this a lot is with police reports, lab reports. If you have a lab report, somebody tests something in a lab and you're in a civil case, that's going to come in under a hearsay exception, but not in a criminal case, because the court has said anything that's testimonial. And what testimonial means is anything that is created for the purposes of the investigation and prosecution of a crime. So when a lab report is done on suspected drugs, that is testimonial. That is a statement that is being prepared in anticipation of a prosecution. A police officer's reports, anything along those lines. If you're doing that, that person's going to have to testify because of the confrontation clause. Now, if it's non-testimonial, and I'll give you an example of that. So the court has said, so imagine a child is abused and they're taken to the hospital, and as part of their initial treatment, they meet with a counselor and they tell the counselor what happened. defense attorneys argued that's testimonial because that is done in anticipation of a trial, of finding the person who did this and punishing them. The Supreme Court said, no, it may have testimonial aspects, but that's not the main reason it's being done. It's being done as part of this sort of medical mental health treatment for the child, so that can come in. So you have that fight too. And that's always in the background of all these questions you have with hearsay. The statements against interest can be one as well. You have Bruin, which we've talked about before. Like there are certain constitutional rules that always are hanging around in the background.
Absolutely. And just to throw in another thing you have to think about, in addition to all these rules on hearsay, is that remember what in one of our legal briefs, I can't remember which one now, we talked about opening and closing statements, I think. Because these rules and exceptions depend on the judge's ruling for admissibility, if you have a doubt whether the judge is going to allow something in, you can't mention it in opening statements. And so it's only when it comes in that you can then point to it in your argument and closing argument. So this is what we mean by it's an ever shifting game of chess. These rules do not exist in a vacuum. They are meant to basically allow some sort of guidance to admissibility, but they are not the end all be all. Just because something is admissible doesn't mean the jury has to believe it. Doesn't mean it's not rebutted by other evidence, for example. It is merely the gatekeeper of whether the jury gets to hear it. So hope this helps. I feel like maybe after 3 episodes, people are more confused than anything. I know whenever I study hearsay more, the more I study it, the more confused I get. I have to just step away at times and feel it as opposed to really know it.
Yeah, look, hearsay, it's endlessly confusing. Judges get it wrong all the time, to our eternal frustration. There's a lot of judges who it's just, oh, that was a statement that was made outside of court. Hearsay, it's not coming in.
And there's a lot of judges that just don't fully understand hearsay. That's the issue. Right. And remember, this is how fast it's happening. We've taken hours, over the course of multiple episodes to explain this. In court, this is how it happens. Okay, well, what did Joe tell you? Objection, hearsay. Counsel, this is not a hearsay because the declarant is now unavailable because he's dead. Overruled. Proceed. I mean, that's how quickly it's going. So that's why you have to have these at the tip of your tongue. You do not have time to look up the rules and be like, which one do I think it is? And depending on the trial, I mean, easily one witness can have dozens of objections to hearsay, and each of them are going to be fact specific that you have to argue for or against, and the judge is making rulings on the spot, and you roll with it. Because if the judge said sustained, you can't ask that question. Now you have to pivot. And you probably were on a roll with that witness. And that's the most jarring to me. Whenever I get a sustained objection, especially with hearsay, I'm like, well, gosh darn it, that was my entire next section of my direct testimony. Now what do I do?
And we've talked about this a little bit before. That's why preparation is so important. And you might go as far as, if you have a key section of your case, which is going to rely on a hearsay argument, filing a motion in limine and saying, hey, just want to make the court aware, we're going to be putting on this evidence. It's not hearsay for all these reasons. And then you're sort of arguing it beforehand, and you're not doing that on the fly thing. And so that's something that you can do too. There are tools you can use to try and narrow this. But the reality is, as Al said, that's one reason a lot of people love trials. It's one reason a lot of people hate trials, because it is just, you're going and you never know when the person is going to stand up and object. And sometimes you didn't anticipate it because their objection isn't very good. Sometimes those are the worst ones because it's a bad objection, but you didn't really think about it. And then all of a sudden the judge is looking at you, counsel, your response, and you're like, oh.
Clearly not for the truth of the matter asserted.
Right.
Just exactly. Cheat sheet. Always say that if you have no idea what else to say.
Exactly. So that's hearsay. Now you guys are experts.
Total experts.
If you live in California, I think California is the one state where you don't have to go to law school to take the bar. Hit it up. Time to be California lawyers.
That's right. Well, should we do some questions today, Brett?
Let's do some questions,
Let's
Alice.
do some questions.
Let's see. Susie Bunny wants to know, I'm curious, when it comes to your experience with appeals courts, how balanced do you feel they are in true crime pop culture? We hear a lot about cases where travesties seemingly happen and upper courts uphold lower courts, to the dismay of true crime enthusiasts who are sure that the lower court was wrong. What's your experience and your thoughts on this perception of the public.
Well, my perception doesn't have to do so much with the appellate courts, but the reporting of what actually happened at the trial level, right?
Yes.
I mean, that truly is kind of the basis of what Legal Briefs is supposed to be, debunking the clickbait types of articles. And I think the perception, perhaps, that the appellate court is just affirming the jury conviction below when clearly there was so much wrong is, did you read the record? Was the reporting actually correct on it? Because the appellate court is based on the record, and typically it's going to be heard, depending on which jurisdiction you're in, 3 judges, whereas at the trial level it's 1. And that type of a structure is meant to basically not have a fiefdom and have kind of more ears to be able to, because reasonable minds may differ. So you have now 3 people instead of just 1, in case you had some one really biased judge who was completely off their rocker. Now you have 3 judges who have to hear the record as it was. The record is what was admissible, and make a ruling on the record. And obviously there are lawyers that are not always great. There are judges that are not always great, but every single judge takes an oath to their office, right? And just like every lawyer takes an oath to their office, and doctors do it, lots of other professions do it. And so to make a blanket statement that appellate courts writ large, there's so many appellate courts, like I can't even count them. There's state, there's there's the state system, there's the local jurisdictions, there's the federal systems. To make a blanket statement that all appellate courts are just to rubber stamp the district court is, I think, pretty inaccurate. You're going to have some judges who are just not good, who may even be biased or, something worse than that. But there are guardrails in the system to prevent that. So I think the premise of the question is a little bit faulty, which is not why is the appellate court always kind of affirming the lower court, but rather, what were you told about what happened at the lower court? Where did you get your information? Was the reporting actually reporting the truth of everything that happened at the lower court?
And it's been said, and I think it's true, that the most powerful person outside of the captain of a ship is a trial court judge. District court judge in federal court, trial court judge in state court, because it is incredibly difficult to overturn a lower court's opinion, and the system is designed that way. And one of the reasons is appellate courts typically deal with the law. They deal with legal questions, not factual questions. Factual questions are the province of juries and judges to a certain extent. And there is this belief that because lower court judges, they see the evidence firsthand, they hear the testimony firsthand, they're making factual determinations, not on a cold record, but on what they've witnessed throughout the trial, that it is hard to overturn factual determinations by a judge. So a lot of times what you'll see is in the appellate court, they don't really question a lot of the facts. They recite the facts. There'll be a fact section, but they're not going to really question that unless something is so obviously wrong or so obviously contradicted by the record. And a lot of times the law is pretty straightforward. So you're, as an attorney, you're trying to overturn this case and you're trying to argue the law, and you're having a difficult time with that because that is really hard to do. Appellate courts typically should not be overturning lower courts. It should be an extreme circumstance. It should be the exception that an appellate court is having to overturn a lower court. And that's the way the system is designed. And I think Alice is right. It's very easy to criticize the final outcome, but if you don't really look into it, and we talk about, we do this every case we do, right? We dive into these cases. We always find stuff. If we're talking about a case that a podcast has done, we always find stuff in it that we are going to highlight that might have been missed. And even Bone Valley, which we loved. We thought Bone Valley was great. We talked about things that weren't really in Bone Valley. And there are reasons that those decisions are made. Same thing with news coverage. Most reporters aren't lawyers. They don't know all these details. And so it's really hard. And that's why I think always, whenever you are tempted to react to some story and think it's just so outrageous, sometimes it is, but a lot of times there's more to it. Now, look, appeals court judges are like everybody else. They've got their views on the law. They got their views on certain things. As an appellate lawyer, there have been times, you see your panel and you're like, this is an easy panel. This panel probably is predisposed to agree with me. And then sometimes you look at it and you say, this one, I don't know. There was this one judge, she's since retired, and it seemed like she was on every panel that I had. And she was always it was one time as I was sitting down, she was like, it's always a pleasure to mix it up with you. And I was like, it's a pleasure to mix it up with you too, Judge, because she had very sort of strong views on the death penalties for death penalty cases. If you really didn't like upholding death sentences, and you really had to bring it. Now, she would do it. She would follow the law. But if there was a loophole, she was going to find it. And sometimes it's that, right? It's just how inclined is that judge going to be to really look for the way out or not? Look, the law is not mechanical. We're not robots. Judges are not robots. They're human beings. They're going to look at things differently. That is the society we live in. I would rather have human judges with human proclivities do it than some AI robot deciding whether or not somebody's appeal should be granted. So it's sort of both a blessing and a curse that that's what you're dealing with, but you're going to see that. You just are. As long as human beings are involved, you're going to see that. That was a great question. Great question.
I did not mean to attack your, because I think that question is asked a lot. So the fact that you asked it, I don't think is surprising at all.
This is from Carl's Raj, who says, I'm in my second year of law school, and I'd love your advice. Tell us about your highest and lowest points during law school. Do y'all have any tips on how you got through it?
A lot of lows in law school.
Yeah, my high point was probably being accepted, and it was all downhill from there.
I was gonna say, my highs have nothing to do with law school. It had to do with like other things around law school. Getting to perform with Yale Repertory Theater, that was a high point. Different school of drama, definitely not the law school.
2L year was definitely my low point. I did not enjoy 2L year at all. 1L year was just, it was great for lots of reasons. You know, it was brand new and it was really hard, and there was something about how it was regimented. Everybody took the same classes. You were learning sort of the things you'd always heard about. And then 2L year, I don't know, I was kind of adrift all 2L year, and it wasn't great. But then 3L year, I kind of found my way, and I played Rock Band the whole time. So it worked out.
I would say the thing that saved me, and if it's available to you, is to find a mentor in one of your professors. This is going to be hard. It doesn't have to be a professor that is in a subject area that you're interested in. It's just, like Brett said, it's very easy to be adrift in law school. There are way more students than there are professors. And sometimes it's helpful to just be rooted through someone. You know, the mentors that I had, not what I ended up practicing whatsoever. We actually disagree vigorously on many areas of the law, but they looked out for me, and they were safe places that I could go when I felt the rest of law school was just crazy. So I would like go sit in one professor's office who I was very close to, or like go to her house, and like we would have dinner, because I was like, I need to be off campus away from all these other crazy people. And like, she became a lifelong friend, still is a friend, still someone I talk to a lot. So if you have that available to you, it can be such a great grounding experience. Not to mention, obviously I care a lot more about relationships than I do about some grade. And the relationship is not a means to an end. It literally is just the relationship, because people matter. And if you focus on other people, it helps alleviate all the pressures that you may feel in law school, which is that all that matters is you have to read 300 pages a night and make sure your outline's perfect and that you have all the right answers. You'll never know all the right answers in the law. That's the secret. And so the sooner you can kind of pull out of it and recognize what may make you a great lawyer is expanding your horizons on what the law entails. And part of that is getting advice and insight from people who've been at it a lot longer than you. And in law school, the most accessible, at least to me, were professors.
I say beating Psychobilly Freakout on Guitar Hero 2 the day before my Fed Courts exam. That was a high point for me. I worked on that a lot.
We're very different people, Brett.
I knocked it out. And then I went and took the exam and didn't really study for it because I was busy doing more important things. And it was fine. So my advice is, you'll be fine. Just get through, graduate, move on with your life.
Advice.
So
enjoy it is what I'm trying to say.
Exactly. That's what I was trying to say.
This has been very fun. If you have any more questions about hearsay, which I can't imagine that you would after our very clear explanations of clear-cut rules, why you would, but let us know. You can email us at prosecutorspod@gmail.com. Reach out to us on social media, on Facebook, Instagram, X, Twitter, TikTok even, at prosecutorspod. And we love hearing from you. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
It's here, Alice.
Okay.
Always
So one of my favorite quotes from Mike Birbiglia. You guys have asked me who my favorite comedian is. It's Mike Birbiglia. But there's this thing where he talks about his wife is always late and he's always early. And he's like, I just don't understand people who are late because you can be infinitely on time and you're just 1 minute and you're late. He's like, you have all the options in the world to be on time.
It's true. That's a good point.
And like the shade he throws at anyone who's late, which in my real life, that's definitely